Welcome to Torn, the only podcast committed to exposing the truth about the child welfare system and its devastating impact on families of color, told from the perspective of your hosts, Sonia Johnson and Classie Colinet, two defense attorneys who have over 15 years of experience working in the child welfare system.
Welcome, everybody. My name is Classie Colinet, and I am joined here with my co-host, Sonia Johnson, and we have another great episode in store for you.
Today's episode, we will explore the different roles of the various individuals that a parent will face when they enter into the courtroom to defend against a child welfare proceeding. Our hope today is to give our listeners a broad understanding of who the people are in the courtroom and who those people work for. But before we do that, Classie is going to set the stage for us.
So I want to take everybody into a real life story of how typically these cases will unfold. So I want to introduce everyone to a parent who I will call Cindy. And I'm just going to give you a quick overview of how Cindy got involved in the child welfare system. So for background purposes, Cindy lives in an underserved neighborhood. She also happens to work 2 jobs and has 2 small children that are both under the age of 5. Cindy decided that she was going to leave her children with a family friend, which she has done many times before. And on this particular occasion, and it happened to be a Friday, while her children were being cared for by her family friend, both children sustained bruises on their foreheads. Someone who lived in the home of the family friend reached out to the police. The police then alerted the child welfare agency, and subsequently both of Cindy's children, who for purposes of this explanation, their names are Leo and Sean. Both Leo and Sean were put into foster care. But on Friday, while Cindy was working one of her jobs, she learned that her children both sustained bruises and both children were going to be immediately taken into Child Protective Services custody. Cindy, as you might imagine, is distraught. She's confused, and she tried her hardest to convince the Child Protective Services worker that her children have never been harmed in her care. But unfortunately, the responses that Cindy kept getting from the Child Protective Services worker was, "You should have known. It's your fault that the children sustain these bruises, and you should not have left your children in the care of your family friend," who, by the way, the Child Welfare Services worker advised Cindy that this family friend has a felony conviction from over 10 years ago. But in Cindy's opinion, this family friend has been very supportive of her and her children. And Cindy is not sure how her children sustain these bruises, but nonetheless, she knows that her children will not be coming home on Friday evening with her. Her Child Protective Services worker told her, "Although your kids are going into foster care, we will figure out a visitation schedule so that you can see your kids on Monday." Her Child Protective Services worker also told her that she has a court date on Monday. Cindy has no idea what is going to happen at that court date. She knows court is on Monday morning, and so Cindy, as any responsible parent would do, she showed up for court on Monday morning. The courthouse is big, and when Cindy walks in, she really has no idea where she's going. The paper that her Child Protective Services worker gave her that tells her about court, it tells her the address of the courthouse, and it mentions a judge's name, but she has no idea what floor that judge is on. So Cindy walks in to the courthouse. She goes through the metal detector, and then she proceeds to ask one of the officers near the metal detector where the judge's chambers is. Cindy is given directions. She goes up to the floor where court is taking place, and she sits in the hallway. Cindy is distraught. She's scared. She's frightened. Her kids are not in her care. She has nothing to do with the fact that her children have bruises on their heads. And what she wants most is to get her children back. So Cindy's case is called. She walks in with her attorney. Her attorney briefly spoke to her before she went in to the courtroom, but Cindy doesn't think it was enough time. So Cindy walks in. She sees several people in the courtroom. She doesn't know who they are. Sonia, I'm going to turn it over to you so you can tell our listeners, who will Cindy see in the courtroom?
So Cindy walks into the courtroom and I greet her. And the first thing that I want to do is I kind of want to put her mind at ease, at least as far as understanding the process and who the players are. So, Cindy, I'm your defense attorney. I'm the one that is going to be representing you throughout these proceedings. I will walk you through. I will help you understand what's going to happen next, what you need to do, how you can get your kids back. I'm your defense attorney. I'm also called the parent attorney. The other person in the courtroom is the Deputy Attorney General. The Deputy Attorney General, or DAG, works for the division. She works with the caseworker, your caseworker, and will put forth the case on behalf of the Division of Child Protection and Permanency. So that's the lawyer for the division. The other person over there, the law guardian, that is the attorney that represents your children. In these proceedings, children, no matter how young they are, get their own attorney. And it's the law guardian's job to advocate on behalf of what their clients, your children, want to happen in these proceedings. The judge will hear all of the arguments, hear all of the evidence, and the judge is the one who will make a decision about what happens. What happens today? Will you get to have your kids return home to you? If so, under what circumstances? And the judge will also let you know what is expected at the next court hearing. So the judge makes all of the decisions. Cindy, in this case, we don't have a GAL, but I just want to let you know that a GAL, or a guardian ad litem, sometimes is assigned to work in these cases when parents are mentally incapacitated and cannot advocate for themselves. You, Cindy, can advocate for yourself, or that you can understand things well enough, and I will represent you in these proceedings, but you don't need a GAL because you don't have a mental incapacity. Another person that works in these cases is someone called a CASA, and CASA stands for Court Appointed Special Advocate. And a CASA is assigned in these cases when children are placed in foster care. The role of the CASA is to meet with the children, to talk with the resource parents, to find out how they're doing in school, to make sure that all of their needs are being met, both in terms of schooling and medical and dental and emotional needs are being met. And the CASA will advocate from a standpoint of saying what they believe is in the best interest of the children. Those are the people that are involved in these cases. Now, Classie, can you tell our listeners what Cindy should bring with her to court?
Definitely. So when Cindy comes to court, she has an option to bring supportive individuals with her. And those individuals can come with her to the hallway and in the courtroom, in the courthouse, and they may be able to come into the courtroom if all of the other attorneys consent to those supportive individuals coming into the courtroom. So Cindy can bring a parent, a sibling, or some other similarly close relative with her. She can also bring family friends, her best friend. And the purpose really for bringing supportive individuals with you to court is because many times those supportive individuals can serve in a supervisory position. If there's an option that the judge is open to, where Cindy can bring Leo and Sean home, she may be able to have her attorney convince the judge that Leo and Sean can come back home as long as Cindy's mom is living in the home with Cindy until the judge is satisfied that Cindy can be with her children unsupervised. And Cindy having the benefit of having her mom already there, if the judge has any questions for the grandmother or another similarly close relative or family friend that's available to be a supervisor, that person can come in and answer any questions that the judge or the attorneys have. And so it could potentially help move the case along much quicker. And in some instances, it can help get kids out of foster care on that day or very close in time to that day.
Classie, what should Cindy have before she leaves court?
Yeah, this is a really important piece to the whole proceeding, Sonia, because so much happens while a parent like Cindy is in the courtroom. And so it's really important for Cindy and any parent to know definitely when is their next court date, who will be the assigned judge, because sometimes judges change. And they also need to know the name of their attorney. The name of a parent's attorney, and I'm going to use Cindy as an example since that's who we've been talking about throughout this episode. Cindy has to be able to reach her attorney right after court, sometimes on the same day, but she should definitely be setting up an opportunity to sit down and talk with her attorney for at least an hour. In my experience, sometimes those initial meetings can go for more than an hour, but that's definitely at the top of the list. And then Cindy also is going to need her court order. A court order is a crucial piece of information because it will explain what steps a parent has to take before the next court date happens. That court order will also indicate the name of the Child Protective Services worker that is assigned to work with the family. That court order in New Jersey will also indicate the name of that Child Protective Services caseworker supervisor, and that's also very important. And it will also have the caseworker's phone number and extension number. And that is very important because undoubtedly Cindy will have to reach out to her caseworker to follow up on the many steps that a judge may ask her to take before the next court date. For example, Cindy may be asked to take a substance abuse evaluation. She may be asked to take a psychological evaluation. So she needs to be able to reach out to her caseworker. And if she can't reach her caseworker, she can reach out to her caseworker supervisor via telephone and ask, when are those evaluations taking place? But also, she can ask any other non-legal related questions to her caseworker.
Now, Classie, those orders also typically set forth the services that the court and the division are requesting. Now, that is not always that's not included in the first order, but subsequently orders that are issued will include the services. So it's important for Cindy to have the order so that she's very clear on what services the state is requiring Cindy to engage in so that she can get her children back. Is that right?
That's absolutely true, Sonia. And another key reason why it's important for Cindy to have that court order that outlines that information is so that she can alert her attorney if her caseworker is asking her to take an evaluation that's not included in the court order, because sometimes that also happens. So this court order is important, not just so that Cindy knows what the judge wants her to do. Like you said, the evaluations won't be outlined, or typically services are not outlined in that first order, but in subsequent court orders, they are outlined, and it's going to tell her what she needs to do, but also it's going to serve as a guide for what she doesn't need to do.
Right.
Because sometimes, Cindy may be asked by her caseworker, hey, can you go take, I don't know, let's say, for example, a psychiatric evaluation, and it's nowhere in the court order.
Right.
But Cindy goes because her caseworker told her. And sometimes a parent like Cindy will go because they don't have the court order. And so they're not able to say, wait, that's not even in here. And this is also why it's important to have your attorney's phone number, because you should be calling your attorney, even if it is an evaluation that's in the court order. Cindy should always be telling her attorney, Mr. So-and-so, Mrs. So-and-so, I want to tell you that my caseworker has asked me to go to this evaluation. It's scheduled for this day and this time. I just want to confirm that this is an evaluation that you're advising me that I should go to. Because, Sonia, you and I both know that even in instances where a judge has ordered an evaluation, sometimes the way the court order is worded is that evaluation is contingent upon another event happening. Right. For example, the judge may say, Cindy to take a psychological evaluation if it is determined that there are some mental health concerns. It's very broad.
Right.
And the question is, should Cindy be going to an evaluation that's scheduled for 2 days after her court date?
Right.
Tells her attorney will tell her, no, Cindy, actually it's in the court order that it's only if there's mental health concerns, and there's no proof of that as of now.
So don't go. Right.
So don't go.
Now, Cindy should also look at the court order because it's going to tell her what her visitation schedule is. And that's also very important, right? So the order will set forth what visitation looks like. It can be 2 to 3 times a week for a certain number of hours. So it'll set forth the duration. It will set forth also the conditions or the preconditions that have to be met before the parent can actually go to the visit. And by that, 24-hour notice, advance notice, because the state wants to ensure that they are not utilizing resources and disrupting a child's day if a parent is not going to come to the visit. So Cindy needs to have the order so that she knows exactly when she will have the visits, how many times she will have those visits with her child. And is there anything else that is in that order that Cindy absolutely needs to pay attention to that you can recall or that you would recommend?
Yes, definitely. Thank you, Sonia. So Cindy is also going to have an opportunity to see if there are other ways for her to stay in contact with her children, Leo and Sean. For example, the court order may say on specific days and certain times, Cindy can see her children in person. And then there will also be a section that talks about other means of communication with her children, such as FaceTime, Facebook messaging, WhatsApp, perhaps even emails that perhaps Cindy can send to the caseworker to tell the foster parent to read, to learn more about who Leo and Sean are. There's also going to be an opportunity for Cindy to establish potentially through those means, the Facebook messaging or FaceTime or phone calls. She may also have an opportunity to establish a relationship with the foster parent. If it is someone that's unrelated to her or someone that she doesn't know, she could potentially also establish a relationship with that person or those people if it's more than one caregiver.
Right.
And in my experience, Sonia, that has been really helpful to parents when they have an open line of communication with the person who is taking care of their child, whether it's someone who is related or unrelated.
Right.
They can really bond together as a team.
Right.
And present to Cindy's attorney, and her attorney can then present to the judge and the other attorneys how Cindy is so involved as a parent. She's so involved as a parent that she's even established a strong rapport with the person that's taking care of Leo and Sean.
Those are the best cases that I've seen when the resource parent is able to become part of the parent's circle of support. And when the parent and the resource parent are able to communicate, because after all, the resource parent is just meeting the child and learning the child. The parent knows, everything about the child. So if those two parties can have a working relationship where they can share information, that's positive and very beneficial to the child. But then also, as the parent and the resource parent bond, the resource parent is able, in some instances, to support that parent and to be there for that parent. And those are the most positive relationships that I have seen. What tips would you give Cindy, Classie?
I'm glad you asked, Sonia. So for sure, Cindy has to be able to prepare for court dates in advance with her attorney. That's why Cindy needs to have the name, phone number, and other means of communication with her attorney, whether it's an email address. I know for myself, I have WhatsApp. And I also have the ability to send text messages back and forth with clients. So that's always helpful.
Now, clients don't have that benefit for that first hearing, but subsequent hearings, they have that opportunity to talk to their attorney in advance. Is that correct?
That is correct, Sonia. There's a caveat there. You're right. In New Jersey, they may not necessarily have the same attorney, because I know at least here in the Garden State, sometimes the attorney may change between the first date and the second court date. But that's for administrative purposes, just based on the way a particular public defender's office is managed. But it's still important for Cindy to get the name and phone number even of that person from the first court date. And I'll tell you why.
Why?
Cindy can call that person between the first court date and the second court date and ask, hi, whomever the person's name may be. Hi, Miss So-and-so. Hi, Mr. So-and-so. This is Cindy. I met you on my first day of court. I just want to call in and find out, are you going to be my attorney going forward, or is there going to be someone else working with me? And that person has the capability to ask a member of the administrative staff in their office who is the attorney assigned to work with Cindy? And sometimes it may be that an attorney has not yet been assigned, but that would also be helpful information for Cindy to have while she is waiting for that second court date to take place. And then, Sonia, there's a second piece of this. And what's really important is in between the first court date and the second court date, I talked about how in some instances, the caseworker may ask Cindy to do things that are not in the court order, or even things that Cindy did not hear at all mentioned in the courtroom.
Right.
Cindy can also tell her caseworker, if such a request is made while she's waiting to hear back about what attorney is assigned to her, she can tell her caseworker, I understand what you're asking me to do. I'm waiting to hear back as to when an attorney is being assigned to me so that I can get legal advice before I proceed and do these next steps that you've asked me to do.
Classie, what you just said is just so important. You and I both know that sometimes, as you said, that having the opportunity to speak to an attorney before parents make a decision or agree to do something can be the difference between a case dragging on for years and a case stopping dead in its tracks, within weeks.
Absolutely.
And so it is absolutely imperative that parents reach out to their attorney and ask for the opportunity to speak to an attorney before agreeing to some of these services. It's also important, and you've already kind of addressed this, to stay in touch with your attorney. Unfortunately, a lot of parents don't communicate with their attorneys until the day of court. And things, there are typically 2 to 3 month gap between the last court date and the court date that's coming up. And a lot can happen within those 2 to 3 months. And as the parent attorney, we don't get that information until shortly before trial. And it's generally information that's provided by the division with the division spin on the facts. So it's really helpful when parents communicate and stay in touch with us as parent attorneys or defense attorneys. Cindy should wear proper attire to court. Am I right, Classie?
She can. Yes, she definitely should. And Sonia, can you tell us why that's important?
Because first impressions really do matter. We're not requiring it, or you don't need to wear a suit and tie, but do know that how you present is magnifying. It is speaking. And so your clothes, you should not have any rips in your pants. You shouldn't have any offensive wording. If you're wearing a T-shirt, no offensive wording on your T-shirt. You should not have clothes that are too tight on, that reveal everything, that leave nothing to question. You should be covered. All of the important parts should be well covered. Classie, did you have anything that you want to add to that?
Yes, no, thank you for that, Sonia. Those are all good points. I'm just going to add no spaghetti straps. So your shoulders should typically be covered by whatever it is that you're wearing. And Sonia, to your earlier point that first impressions are lasting impressions, I think it also helps set the tone for the judge and the other attorneys about how serious a parent is about getting their kids back.
Right.
So for better or for worse, and we talked about this in an earlier episode, people do make assumptions based on how you look. It's a natural tendency. We all put each other in proverbial boxes. And so from my vantage point, I would encourage Cindy, we want them to think the best of you. We don't want to leave any room for interpretation. And so me as Cindy's attorney, that would be part of our initial conversation. Do you have something to wear to the next court date, or do you need help? Because in some counties, at least in New Jersey, there are opportunities to access donated clothing right at the courthouse. I know for sure, at least one of the South Jersey courthouses, there is an actual donated clothes section, and it's available and open to everybody. So we have to be able to help Cindy make the best impression, because we don't want anyone in the courtroom to get distracted by what she's wearing.
That's very true. Very true. Classie, how best should Cindy address the emotionally intensive feelings that she's having as a result of having her children taken?
This is a really good one, Sonia, because naturally Cindy is upset. Understandably, she wants to probably take off her shoe and throw it at everybody in that courtroom, and particularly at the caseworker.
Well, and we've had cases where we read in the complaint, mom said blippity blip 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 to the caseworker. Mom then said blippity blip 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 to the police officer that had to come get mom off the caseworker.
Right.
And so it's not helpful. And it's not helpful because the judge will read it and walk away with an impression. And again, you just said first impressions are lasting impressions. So it's not just how you appear physically, it's also what the judge is taking away from what's being described in terms of how you're behaving. So then your behavior in court is either going to endorse that or not. So we've seen that, right, Classie?
Absolutely, absolutely. And what's really important, Sonia, is that parents like Cindy, that they, as hard as it is, that they take a step back and use their attorney to their advantage. Vent to your attorney, tell your attorney how upset you are at various individuals involved in the case. You can, in some instances, I know for me, I've had clients come and tell me quietly exactly what you were saying, Sonia, like, I want to blippity blip 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 that caseworker, mm-hmm. right? Or something else that they want to vent about. And I'm okay with that. I understand that as an attorney, I'm not just giving legal advice, but at least in the child welfare system, in many ways, I am a safe space for my client where they can safely vent and not be worried about someone carrying it on to share with anybody else. But it's really important not to let your emotions get the best of you. Do
Right.
not let your emotions consume you.
Right.
Remember, again, just like how we talked about what you wear and first impressions are lasting impressions, the same applies to emotions too. Parents that have outbursts in the courtroom, no one ever forgets those outbursts.
Right, right.
They always remember them.
Right.
And then what happens is naturally, and I know this even happens to myself as a parent attorney, we forget about everything else, right? These cases are about the children, Leo and Sean.
Right.
It's not about Cindy had an outburst. That's minimal. But it can become about that if Cindy and parents who are in her position forget to control their emotions.
And you know what else is important, Classie? It's because it's a fine line between we want parents to feel heard, but then we have to make sure that they're heard in a certain way. And so oftentimes parents are very emotional and they want to say what they want to say. And as a parent attorney, I have to make the judgment call as to whether I should be the vehicle to say it. And so I try to communicate that up front. Parents will say, well, I want to talk. And if I know that it's a parent where their talking on the record is going to create more issues than resolve them, I will say, well, let me do the talking for you. I can convey what you're trying to say, and let me do that. Because I want my client to feel heard, but I also want to make sure that what's being communicated is actually helpful to the outcome of the case. And Classie, our final tip is, if Cindy feels that her attorney is not representing her well, is not listening to her, what should Cindy do?
This is another great question. Cindy should seek out another attorney. She can seek out an attorney of her choice just by going to her local state bar association. She could also use Google, right? Or she could reach out, if it happens to be an attorney assigned to her through the public defender's office, she could reach out to the administrative staff in that office and ask to be assigned a different attorney.
But Cindy, one caveat is that Cindy should make sure that it's someone that has experience in the child welfare arena, because this is a very particular area of practice. And I remember, and perhaps we'll close with this, a case that I had where the case was not moving fast enough for the client. The client had mental health issues and had substance abuse issues. And there was real concern about the interaction between the parent and the infant child. And the parent also did not have anyone that could reside with her so that the child could remain in her custody. And we were working the plan. And by that, the division had put in several services. My client was going to the services and doing what she needed to do, but the individual therapy that she needed was taking some time, and it was going slower than what she had anticipated. So she did not like how things were progressing. So she went and hired a private attorney and paid a lot of money for that private attorney. And you know what happened, Classie? The case progressed on the track that it was progressing. It did not progress any faster. And at the end of the day, a judge is not going to fast track a case just because there's a private attorney on it. Because at the end of the day, the judge does not want to be in the newspaper because they released a child to the custody of a parent who was not ready, who was not safe. Classie and I hope that this episode gives parents a better understanding of who is involved, who the players are when they walk into the courtroom, and to begin to put the pieces together and make good decisions about how to communicate their side of what is happening in their child welfare case. Until next time.
The opinions and views expressed on this podcast are those of its hosts and guests and represent our own lived experience. The views and opinions expressed do not reflect those of any agency or organization with which we may be associated.